Welcome to literary and jury charge practice. Let's get started with some jury charge. Ready? The instant suit was brought in the district court by the union, which prayed that the board's order of decompliance be enjoined. International Scientific Company intervened. The district court denied a preliminary injunction. The Court of Appeals held that a false affidavit filed under Section 9H of the Act gave rise only to a criminal penalty against the guilty union officer and did not in any way alter the union's right to the benefits of the Act, even where its members were aware of the officer's fraud. We agree with the court below that the board has no authority to deprive unions of their compliance status under Section 9H, and that the only remedy for the filing of a false affidavit is the criminal penalty provided in Section 35A of the Criminal Code. We start with a statutory provision that contains only one express sanction, namely prosecution for making a false statement. No other sections of the Act expressly supplement that one sanction. The aim of Section 9H is clear. It imposes a criminal penalty for filing a false affidavit so as to deter communist officers from filing at all. The failure to file stands as a barrier to the making of an investigation by the board and the issuance of any complaint for the benefit of the union in question. The section therefore provides an incentive to the members of the union to rid themselves of communist leadership and elect officers who can file affidavits in order to receive the benefits of the Act. The filing of the required affidavits by the necessary officers is the key that makes available to the union the benefits of the Act. The board is under a duty to determine whether a filing has been made by each person specified in Section 9H, since its power to act on union charges is conditioned on filing of the necessary affidavits. The argument made by the board would have us read into the Act an implied power to determine not only whether the affidavit has been filed, but also whether the affidavit filed is true or false. Now for some literary practice. And this is the title of this literary is called Court Reporters, Entrepreneurs, and More. Court Reporters, Entrepreneurs, and More. Ready? For two Connecticut court reporters, being excellent in their field is just not enough. Both have jumped into second businesses to showcase their creative sides, and not surprisingly, their efforts are aimed squarely at what Americans crave: ice cream and chocolate. Alyssa Ferrero of Wethersfield has lived through terrible loss and amazing love and finds a silver lining in every occurrence. She lost her son CJ in 2003 when he perished in a car accident at the age of 17. 2 years ago, she informally fostered her friend's newborn girl, who has recently gone to live with blood relatives. Ferrero owns A+ Reporting Services and takes everything from car accidents, dog bites, and divorce to medical malpractice jobs. I would say MedMal is my favorite because it's challenging and extremely interesting. I was a former medical transcriptionist, so it's right up my alley, says Ferrero. Maria Boyle Hughes of Norwalk could be one of the most focused people on the planet. Full disclosure, she's my boss. She'd planned to go to law school after graduating from the University of Connecticut, but then I started working at the local courthouse and met the court reporters there and decided to change my career path, she says. She owns Campano and Associates Court Reporting Services with a stable of 20 freelancers and takes 4 jobs herself nearly every week. Her business has been voted the best court reporting and deposition services 7 years in a row by the Connecticut Law Tribune. Hughes always craved an opportunity to show the right-brained side of her personality. After taking weekend classes in New Jersey with other chocolatiers and waiting for her kids to be in college, she was ready to launch. I've always had a sweet tooth, she says. So I started Diamond Chocolatiers, which is an online chocolate company. We make delicious, decadent, and delectable chocolate. During the week, her life is nonstop court reporting, managing the business, billing the clients, and editing transcripts. But on the weekends, it's all about the chocolate that she produces from a rented, licensed kitchen 10 minutes from home. There's always that delicious aroma when we're cooking, she says. What's not to like? Ferrero calls herself a huge risk taker. Life is too short not to really have fun and live to the fullest, she says, admitting that it's probably fallout from when my son died. But she adds, I love ice cream, and it is a far distance from court reporting when you consider all the bad things we hear day to day. She opened Coneheads in Colchester last June and says the business is holding its own. Now for some more jury charge practice. The subject of this jury charge is evaluating evidence. Ready? Gentlemen of the jury, upon retiring to the jury room, you will select one of your number to act as foreman. Neither by these instructions nor by any words uttered or remark made by the court during this trial does or did the court intimate or mean to give or wish to be understood as giving an opinion as to what the proof is or what it is not, or what the facts are in this case, or what are not the facts therein. It is solely and exclusively for the jury to find and determine the facts, and this they must do from the evidence, and having done so, then apply to them the law stated in these instructions. The instructions given to the jury are and constitute one body and series, and should be so regarded and treated by the jury. That is to say, they should apply to them the facts as a whole, and not detach or separate any one instruction from any or either of the others. preliminary to your being accepted and sworn to act as jurors in this case, you were examined by both plaintiff and defendant as to your competency and qualifications to act as jurors. As a part of this examination, each of you answered all questions asked by both plaintiff and defendant. Your answers showed that you were competent and qualified to act as jurors, and the parties to this suit accepted you as jurors on the faith of the truth of your answers. The answers you then made to such questions in regard to your competency, qualifications, fairness, lack of prejudice, and freedom from passion and sympathy are as binding on you now as they were then, and so remain until you are finally discharged from further consideration of the case. It would be improper and unlawful for any of you to disregard those answers that rendered you competent jurors. The jury are instructed that all reference to evidence in these instructions means only such evidence as the court has admitted in this case. Evidence offered but which was excluded by the court is not entitled to and must not receive any consideration from the jury in determining the case. Neither must the jury give any consideration to, nor be influenced by, any evidence which they may have heard, but which was afterwards stricken out by the order of the court. Evidence which was stricken out by the court must be totally ignored and treated as if it had not been heard. Back to some literary. Ready? I love to be busy, and I work best under pressure, Ferrero says. I even bring my laptop and work at the ice cream shop during the slow times. Ferrero had run a coffee shop in Middletown in 2012, but when it floundered after a year, she says, we were lucky to find a buyer and ran for our lives, vowing never to go into the restaurant business again. She decided ice cream was lower overhead and she could handle it, but she had another reason. I just had to do something, so I had a social life, she admits. That's my favorite part. Our friends and family stop in to visit and have ice cream. I have a couple of close friends who come to help if I'm there alone. And I have to add, it's amazing the number of friends who ask if they can come and scoop with us. Both Hughes and Ferrero rely on family to help them run these businesses and pretty much use their weekend time for this work. Ferrero's significant other runs Coneheads full-time, Monday through Sunday. Although Hughes also hires per diem help, her younger son Dylan, who commutes to college, plays a big part in Diamond Chocolatiers by making the products, overseeing the kitchen, and shipping the orders. He researched the equipment they would need in the beginning and even drove his truck to New York to pick up an important piece. Ferrero says, when we opened in June, I was there every single minute. I could be there, running there after work, before work, whenever I had a second. I am so blessed that my son Luke worked there for part of the summer free of charge, and my significant other's daughter, Rachel, who is a graduate psychiatric nursing student at Johns Hopkins, did the same. They actually put together the POS, point of sale system, with an iPad, since we had no idea what to do with that. In addition, Ferrero's unique family situation meant she had to hire help for several months. She credits colleague Danny with last-minute coverage of her clients. And both women have made sure that giving back is a part of their work. Hughes has created JCLIT for Heroes. She and her son Michael traveled before Thanksgiving to the VA Medical Center in West Haven and personally gave JCLIT to cancer outpatients and their families. I needed to get the business up and running before I could do this, she explains. Hopefully, we can someday expand to other veteran groups. This is just a small way of saying thank you for their sacrifices for our freedom. Through Coneheads, Ferrero has done fundraising for the schools in town and even sponsored an ice cream social for the local over 55 community condominium association. I now know we all have a purpose, and I am so happy to know that through both love and loss, pain and sorrow, I can still stand. It is all because I know there's something to hope for right around the corner, says Ferrero. Life twists and turns, and we don't get it a second chance. I want to grab the good, the bad, and the ugly and shake it all up. And is there anything more good than ice cream for Ferrero and JCLIT for Hughes? They don't think so, and neither do their customers. All right, let's get back to our jury charge. Ready? The instructions given to the jury by the court must be accepted by them as the law governing this case. The jury will not be justified in finding a verdict contrary to the law as laid down in the instructions given by the court in this case. The jury are instructed that in this case the plaintiff is suing for commission as a broker on the sale of a certain piece of real estate formerly held by the defendant as trustee, and the burden of proving by a preponderance of all the evidence that the defendant was and is indebted to the plaintiff as claimed by him is upon plaintiff. In order to recover, the plaintiff must prove by a preponderance of the evidence that the plaintiff was the procuring cause of the sale made by defendant to Hart and Newton. So if the plaintiff has failed so to prove by a preponderance of the evidence, or if you believe the evidence upon that issue preponderates in favor of the defendant, or you are unable to say on which side is the preponderance of the evidence, your verdict should be for the defendant. The jury are instructed that while, as a matter of law, the burden of proof is upon the plaintiff, and it is for him to prove his case by a preponderance of the evidence, still, if the jury finds that the evidence bearing upon the plaintiff's case preponderates in his favor, although but slightly, it will be sufficient for the jury to find the issues in his favor. The preponderance of evidence in a case is not alone determined by the number of witnesses testifying to a particular fact or state of facts. In determining on which side the preponderance of evidence is, the jury may take into consideration the number of witnesses testifying to a particular fact or state of facts, and they may also take into consideration, so far as shown by the evidence, the opportunities of the several witnesses for seeing or knowing the things about which they testify. And that will conclude our literary and jury charge practice.